Sandusky family is very disappointed, obviously, by the verdict of the jury, but we respect their verdict. You may recall, for those of you who have been with this case from the beginning, that we said that we had a tidal wave of public opinion against Jerry Sandusky and the charges filed against him, that he had been determined to be guilty by the public and the media from the very outset of the charges, and that we had an uphill battle. I used the analogy that we were attempting to climb Mount Everest from the bottom of the mountain. Well, obviously, we didn't make it. We always felt that Jerry's fairest shake would come from a Center County jury, and we still believe that. The jury obviously believed the Commonwealth's evidence, believed the Commonwealth witnesses. That's clear from their verdict. I've been asked already inside, is that a surprise? And no, actually it was the expected outcome because of the overwhelming amount of evidence against Jerry Sandusky. You may also recall that we asked for a continuance on a number of occasions on the basis that we needed more time to sift through the thousands of pages of materials to determine what other types of defenses we might have, but due to judicial constrictions, we were forced to proceed to trial at this time. I think most of you would have agreed with me that had someone said last November and December we'd have a trial in early June, that you would have agreed that that was not very likely at all, and yet here we are with the trial now that has concluded, and it's still the latter part of June after 3 weeks in court. We have some appeal issues we'll pursue. We feel we have some decent appeal issues. I do want to say this. The prosecution handled the case in an exemplary manner. They're professionals. They presented their case in a solid fashion. We congratulate them. The judge in this case was marvelous. Judge Cleland was the ultimate jurist. He was fair. He was firm. He was reasonable. With everything we asked for, the only disagreement, obviously, we had was our request for a continuance. But aside from that, it would be my privilege to serve in front of Judge Cleland in the future in any sort of case, knowing that he would give a defendant and give counsel a fair shake and a fair trial. We believe he did an outstanding job. Again, as with any case, there are issues which we will take up on appeal. A number of people have asked me about what happened with Jerry Sandusky not testifying after we spoke about that. Now I could talk about it. We had a gag order in place which prevented us from doing so. But late last Thursday afternoon, just before the Commonwealth was to close its case, the Commonwealth asked the court to allow the Commonwealth to keep its case open, at least overnight, because it had just come into information that it wanted to investigate. Later Thursday evening, I received a call from the Commonwealth attorneys, at which time they indicated to me Matt Sandusky had gone to them, had contacted them late Thursday afternoon, then made a statement to them Thursday evening indicating that Jerry had abused him years earlier, and that they were thinking about introducing Matt Sandusky as a witness at Jerry's trial in this matter. I objected. The court was involved in that conversation. I indicated that our whole case was predicated with Jerry testifying, and Jerry had always wanted to testify. However, the next day, the Commonwealth attorney advised me it would not call Matt Sandusky in its case in chief, that it would reserve the right to call him as a rebuttal witness depending on what evidence we presented. That created a real dilemma for us, because if we call Jerry Sandusky now as a witness, it would almost certainly, and we looked at all the different ways we could avoid it, but almost certainly would have resulted in the Commonwealth being permitted to call Matt Sandusky in rebuttal. So reluctantly, and I say reluctantly because Jerry Sandusky still wanted to testify, he denied that he had ever inappropriately had contact with his son Matt. And in fact, and in fairness to Jerry, the remaining number of his children, as well as his wife, felt the same way and were prepared to testify against Matt if Matt came forward at Jerry's trial in this matter and indicated that Jerry had abused him. But that being said, we decided as a legal strategy position that to put Jerry on the stand, to set him up, to have Matt come in to this jury and testify against him would have absolutely destroyed whatever chances he had at acquittal. And so upon our advice as his attorneys, he reluctantly agreed not to testify. And of course, that resulted in Matt Sandusky not testifying. And we felt that that might at least give Jerry an opportunity to be acquitted of some, if not, more of the charges involved against him. So that was the reason Jerry didn't testify in this trial, contrary to my opening remarks that he intended to. I didn't smokescreen you. I didn't mislead you. He fully intended to testify. Are there
45 out of 48 counts? Does this prove to you that your client is sick?
The question is, does the fact that 45 out of 48 counts were returned as verdicts of guilty by the jury, does that prove to me that my client is sick? And the answer is no. Folks, there are lots of people sitting in jails all across this country who are innocent. There have been people, lots of people. May I finish? Lots of people over the years who have been executed for murder and later determined to have been innocent. So what this tells me is this jury, folks in the media, can I finish? What this proves to me is I believe the jury acted genuinely. I believe the jury acted in good faith. I believe the jury acted on the evidence that was presented to it. And I don't dispute or have any problem with the jury's verdict. We had a good jury. Well, you may recall the question is, why would Matt come forward now? You have to ask Matt. But you may remember is what I'm going to say is exactly what you just commented. You may remember the first day of trial, Matt was seated with his family, and actually, according to family members, during the testimony of one of the witnesses, was kind of mocking the witness and indicating that he didn't believe what the witness was saying. We had no idea what happened. And that's something that Matt and whoever represents him will have to tell you later. Yes, we had anticipated Matt would be one of our witnesses, and we were shocked by it. His family was absolutely shocked by it. His parents, his siblings were distraught by it, but nevertheless, that's what we were facing. Jerry said that Matt has had problems ever since Matt was with them, and that these problems had led Matt at times to do things that were irrational. Matt had had problems as a juvenile, and that there were explanations for it, but unfortunately, as I said to Jerry, that if Matt were to testify, because of the fact that this was a surprise situation, the jury would undoubtedly believe him, regardless of what evidence they had. Jerry indicated he was disappointed by the verdict, but obviously he has to live with it. I don't know.
Was Matt living in the house when the trial started?
Matt, I can't say he was living in the house, but his parents had told me Matt had been staying there temporarily recently. And apparently there was some issue with his home life where he was staying with his parents. Well, we have the continuance request, for one. We have the inability of at least one of our experts to appear in court. We have the voluminous amounts of discovery materials that we got as close as 2 to 3 weeks before the trial, which we didn't have a chance to review. I mean, I don't know what you folks thought about the trial, but we were running many days by the seat of our pants, just trying to catch up. Maybe it didn't look like that, but that's the condition we found ourselves in. We also have some trial issues. We have some evidentiary issues, which we'll address in post-sentence motions, which can't be filed until after the sentencing. Is that it, folks? Essentially, the sentence that Jerry will receive will be a life sentence just due to the length of it.
If you folks can move back to
Defense attorney Joe Amendola.